And at the moment, we're obviously all stuck at home. These private FDRs, they can be done via Zoom video conferencing.
Absolutely. We can carry them out remotely or Skype for business, ideally not on the telephone. But if push comes to shove, I have conducted a full final hearing on the telephone recently, but ideally not on the telephone. But yeah, we can certainly carry them out remotely, and we can engage people in a way that wouldn't necessarily have been the norm prior to this situation, because we are finding new ways, with everybody else, we're finding new ways of working, and if we can offer anything remotely, we will.
Yeah, and I think you touched on this earlier, but if the parties reach an agreement at the private FDR, what then happens as far as getting that agreement to be made binding?
We draw up something called, oh, excuse me, we'll start that again. We draw up something called heads of agreement. And the parties you can sign as an indication of what you're intending to agree. So that's the great thing. You've reached an agreement, the pressure is off. And so we draw up heads of agreement. It's not a binding contract. Emphasize that now for the reasons that I've already touched upon, in that the judges in court will approve or not approve any draft consent order that we send in as a result of the heads of agreement. So we reach heads of agreement. This can then be reduced to a draft consent order, which can be sent to the court for the court's approval. Now you may think, well, what if I agree to something? What if we have this private FDR, we reach an agreement, but then my other half decides to withdraw from it or resign from it? And then, unsurprisingly, there have been cases where people have tried to do this. On the whole, provided there hasn't been any issue with material non-disclosure or any other issue that may affect the validity of the agreement that's been reached, so provided everything is upfront in the way that we would hope that it would be, on the whole, the courts have considered that the fact that parties have entered into a heads of agreement, and they would want a very good reason why one person says they should not be bound by it. So there would need to be a significant change of circumstances or another good reason, which currently escapes me, as to why that individual shouldn't be bound. So the courts are usually in a position to endorse the agreement the parties have made. And that brings me back to the issue of it must be a realistic agreement. It can't just be one party rolling over, to coin a phrase, for the benefit of the other one. Because that won't necessarily be approved by the judge when we send in a draft order for the court's approval. So they are binding, or can be made binding, in the way of the heads of agreement. Some people have tried to argue that they are entitled without prejudice, which means that they wouldn't be put before a final hearing. And I'll come on to that when we talk about we can't reach an agreement. Yeah. So it has been argued in the past that these heads of agreement are not able to be put before a judge at a final hearing. But the Court of Appeal has been fairly clear on that, and that the parties must show a good reason why they don't intend to continue with the agreement that they reached at an FDR, whether it's a private FDR or an FDR in court.
Okay, perfect. And what if they don't reach an agreement? So they go along to the private FDR, an indication's given, and one or both parties still isn't happy to reach an agreement. What happens then? Well,
unfortunately, people can't always reach an agreement. And if that happens, then you would carry on with the court process to a final hearing. You could, if you've conducted a private FDR at some stage where you've started proceedings and maybe you've had the first appointment, so you've had your questionnaires and you've responded with the answers to the questionnaires, you may ask the judge to proceed straight to a final hearing on the basis that you've conducted a private FDR. At the final hearing, it's vital to remember that the private FDR that we carry out is what's called without prejudice. So it's the whole point of an FDR is to put cards on the table, say, this is what I would like to settle at in order to resolve matters. But if you can't reach an agreement, then the discussions in this private FDR, or the court FDR for that matter, would not be discussed before the judge at the final hearing, who would be a different judge to the one that carried out the court FDR, if that's what you had in the first place. And obviously, as the person carrying out the FDR, I wouldn't be a lawyer representing either party, because once a person has carried out an FDR, they would, not as a lawyer, but as a party or as a person seeking to assist the parties to reach an agreement. But once you've carried out an FDR, you couldn't do the final hearing or couldn't conduct the final hearing, simply because of the fact that you know the without prejudice position of the other side, or of both sides.
Perfect. And so finally then, obviously you've been dealing with cases like this for a number of years. So what advice or snippet would you have for anybody that's currently going through financial proceedings, particularly whilst we're in this sort of lockdown situation?
Okay, well, the lockdown situation, as we all know, as we hear every day on the news, is unprecedented. We hope that it'll be concluded reasonably soon, but how long that may be as long as how long is a piece of string. And so there's a significant level of uncertainty, unfortunately, amongst couples. And you see in the media of people with difficulties, perhaps even living under the same roof, separated but within the same property in lockdown. So if parties can speed up the resolution of their differences, of their disputes, if they can do so in a way that is measured and properly carried out, then that has to be a good thing. There's also the cost aspect, because if you go to a court-conducted FDR, the judge will always remind the parties, usually looking over the shoulders of the lawyers and talking straight at the parties. The judge will always remind the parties that whatever their costs are up to the point of the FDR, if they go to a final hearing, they're going to at least double, because the work that's carried out is significant in the preparation for the final hearing. And so, yeah, the cost aspect, if you can resolve matters reasonably soon and reasonably cost efficiently, then that must be a good thing for parties. The really important thing coming to any voluntary FDR is to come with an open mind to having a settlement. Because if you can't own the settlement that you have with your former spouse, then you run the risk of not only having months of delay perhaps, and the emotional hurt and unhappiness that goes with that. The amount of weight that is lifted off of people's shoulders when a financial remedy proceedings are concluded is enormous. But you must want to negotiate a settlement. Otherwise, you may be engaging in a pointless exercise. If you want to go to an FDR to prove that you are right, or to prove that somebody has done something that they shouldn't have done, then that probably isn't the reason to go to an FDR. You go to an FDR in order to want to settle a case, and in order to want perhaps to give up some aspects that until then you thought are things that you simply cannot go back on. But it is essential that people come to an FDR with an open mind in order to be able to resolve the issues that they've got with their former spouse, and for the benefit of the family. You need to have a holistic view, because if you have, as I said earlier, if you have red lines that parties simply do not want to cross, historically I've had cases involving cutlery sets, which are clearly very important to the parties individually, but to hold up a financial agreement over a cutlery set, even when it was suggested they could have half each, didn't cut it, and we had to go to a final hearing, at which neither party got what they wanted, and the judge didn't make a decision on the cutlery set. So they were still arguing over that. So you must have the genuine intention and the desire to settle. Otherwise, you would simply be going on one further step along the way to your final hearing.
Yeah, perfect. Well, thank you very much for taking some time out of your day today to have a chat with us about the private FDRs. It's been really, really helpful, some really useful information there.
My pleasure. Thank you. Thank you for inviting me.
Thank you.